Okay, all right. Part five of our family law primer today is going to be about the trial itself. So we've talked all about bringing in a client, the negotiation phase, and all the different parts of negotiation. We talked about mediation, and now we're in and did pretrial. Now we're going to be talking specifically about the trial itself, and really that the entire process of what that's going to look like going through that. Okay, as far as a trial goes in family law, you can throw out a lot of the things that you were taught in, advanced trial ad and some things like that you'll be going through. Most of that is jury oriented, and pretty much the things we're going to be talking about are all going to be bench trials. So there are times where family law is going to have a jury and family law torts and things like that come up to it. But for the most part, you're going to be dealing with a bench trial. So first and foremost, you got to get the case on the calendar and get those court dates. We've talked a little bit about what notice of hearing is and what the pleading is going to look like and how that's going to be. And of course, each county and family court and things like that are going to have its own idiosyncrasies about how that's going to happen. Usually, there's going to be a calendar call, and the calendar call may happen the day of trial, but oftentimes that's going to happen beforehand. You want to make sure that your trial is, gets as much priority as possible to get it in, and sometimes that means being a little bit thin on how much time you've said that this trial is going to last. You don't want to be necessarily the person who has that reputation for saying it's going to be a 1-day trial and it's going to be, and that actually is going to be a 3-day trial. You want to be accurate about it, but you also want to be heard. So, and if the judge hears something besides a 2-day trial, they start getting a little freaked out. So think about that long and hard before you can do it, because you want that trial date is so important to be able to get that thing cranked out. But whatever it may be, let's say at this point, let's assume that you have your trial date. So first thing you're going to be doing is remembering that, in my opinion, more than any other area, you need to know the judge. And if you are a relatively new attorney, or you're going to a place where you don't know the judge, you want to do some backgrounding. And that's one of the things that this practice area group is really going to be helpful for. And that is knowing the different judges and what their predisposition is going to be. Some of that predisposition is going to be about how they rule on certain issues, like who gets custody. Are they a 50-50 judge? Are they some kind of different kind of judge, or where they do? But some of the information you need to know is how do they run their trials? And that information is gold. You need to be doing as much research as you can on that judge before you go in that. But so most of the things I'm going to talk about are generalized for every trial that you want to do, but a lot of these things are going to be specifically based on how that judge handles their own information. First of the things is in trial, you are probably not going to be able to make a opening statement. Judges generally will just be like, okay, call your first witness. It is completely fine if their judge is that detailed to say, Your Honor, before I do that, if I could just briefly summarize to the court what this case is about. Almost no judge is going to stop you from doing that. So if your judge is at the most tabula rasa, every case is going to handle its own way, call your first witness. You still could say, like, okay, Your Honor, before we get started, let me summarize our position in this case. Okay, let's just say it's the worst kind of judge possible, and the judge is like, okay, no, I'd rather just go ahead and get right into the evidence. Okay, then do that. But let's assume for a moment that the judge does allow you to do that. Obviously, you have to be brief. You need to have in your mind a 30-second version of what this case is going to be. So it's possible in open court, you may be giving an opening statement that is literally 30 seconds long. And it may be something like, Judge, this is a situation where we just have the issue of custody to deal with. My clients had custody through 3 pretrial orders and really the entirety of the children's lives. We just would need an order that solidifies that and gives us a good schedule for the defendant. But that's your 30 seconds. It may be that, like, my client has gotten every other weekend for the past year. He should be getting 50-50 split. That's what this case is about. Get to the heart of what really is, move that quickly. Now, most judges will not be that way. They will want to do a pretrial conference, usually away from your client. So this is your most common way family court is going to run. So not only do you need a 30-second version, you need a 5-minute version of what's going on. So you want to have in your mind a 5-minute, this is why my client should have custody. And usually you want that to be because your client in a custody case is the one who is going to be the best co-parent solution for the court. The court won't, that you're the one that is extending across the aisle. You're the one that's going to do this. This is normally not a good chance to rail on the defendant. This is usually a good chance for you to say, Judge, this is what's going on. But if it wasn't for that pesky defendant, then you can rail on them a little bit. But my client is the one trying to reach out, but for their actions. You see what I'm saying? So it's not like, look how bad they are. We're not getting yet into the beauty pageant. Look how good my client is. Look how bad it is. My client just wants to be a normal human and co-parent a child, but he prevents me, or she prevents because. Be firm, but not argumentative in your pretrial. Judges, I've never seen a judge. It's like, oh, I love dealing with that attorney. They're always screaming at me in chambers. In general, though, you don't want to be a pushover, especially if you're a young lawyer. You're going to get that. These guys that have been doing this for a long time, and I say guys because a lot of them are older guys that have been doing this since the 70s or whatever. And you're just going to be like, okay, I'm not going to let them trigger me. I'm not going to be intimidated either. I'm going to stay right to my guns. Here's what's going on. It's okay to let them speak first. You don't have to be in a rush to do that. I really do believe the judges will listen to both sides and, would be that way. This is a good chance for you to have your notebook, flip it over to your trial brief and just be like, Judge, this is what's going on, but be firm about it, about what that position is. If the judge starts to make a decision based on just hearing from one side, and you always hate going to a county, Guilford County, and then you walk in and the judge, like, hey, how's your golf game last week? Everybody, you're like, oh crap. Okay. I'm the out of towner, the judge, the other opponent, party is kind of flexing the home court advantage they've got with the judge. I think it's great to be able to say at that point, like, Your Honor, this is my first chance at your courthouse. I love it. It's beautiful. Do something that just says like, hey, I acknowledge I'm an outsider, but that doesn't change where I am in the case. And I'm very comfortable in my own skin, wherever I am. And, I'm eager to do this. Like, just want to make sure that I've got this down. I think that this is a case where my client should get custody. Liberal visitation schedule probably works in this case. I think you're going to hear some things that will distress you, and probably explain what my client's position is, and I can talk about them now. I'm not a big fan of sabotaging the other side, being like, well, I'll wait till my secret witness comes in, judge, or whatever. I think you try to be pretty clear about it, but you need to answer these 2 questions. What is this case about? And why are the parties not settled this matter? Most judges will not ask the second question directly, but they're going to want to know kind of like, well, is this really about college tuition? Is this about, something that's a little bit bizarre, that whatever it might be, because some judges, a lot of judges are they're jaded. They've just heard so many cases over so much time. And they'll be like, oh, I know what's going on here. It's the new boyfriend. And both you and the attorney both are going to look and be like, oh my gosh, that is clearly not what this case is about. And now the judge is convinced that this is, that they figured it out. They have, because they're kind of jaded, they've heard it before, and they kind of see some things that are pattern or whatever it's going to be. Bottom line is, a lot of judges are going to tell you straight up or non-verbally what they believe this case is about. And I believe it is the best thing in the world for you to say, well, Your Honor, in light of what you said, I need 5 minutes with my client. It doesn't matter if your client is like, there's no chance in the world my client's going to change their mind. The judge might need to hear that, hey, you are open as an attorney to taking advice from them. And, that's a good chance at the outset to be like, okay, Judge, I'm hearing what you're saying. Can I get 5 minutes with my client? And then you can go back and say, like, Your Honor, I've informed my client where I believe that what you've told us, and I think we're still going to need a hearing. Most judges will respect that, but they do want you to give it a chance. And they want to hear that you're giving it a chance. Even if you're like, ain't no way they're going to ever agree to that. Let's just have the trial. It'll be easier than that. But at the same time, don't say, well, that's great, Judge. I think we just all need to talk to clients, because let me tell you, I have seen judges that seem so impatient in the morning that are fine to wait hours for you to go back and forth with the other attorney. So I really recommend you saying 5 minutes. I want 5 minutes to talk to my client, and then we can get started. Because if you don't, you're going to be back and forth for hours trying to negotiate it. Now, you may still be, because the judge will play this role back and forth. And it is just so hard. You're like, let's just start the trial. I could be done with my trial by now. But I think if you say to them, give me 5 minutes and we'll start the trial, then, it gives the signal to the judge, I'm ready for the trial. I want to do this, but I am hearing from you. And I think that that's enough to do it. And you'll know if you're making progress or not. If you're like, hey, I think we're seriously making progress in this thing, then it may be okay to settle it there. I'm not against that concept. I'm just saying, don't play the game where you've back and forth with the other side till 3 o'clock in the afternoon, and now you're starting a trial, because that has happened to all of us. And anything you can do to see that from happening is going to be helpful to you. Okay, you guys have any questions about that pre-trial process on the day?
I have a comment. It's not really a question. Kind of piggybacking off of what Brian was saying. It's really good too, because if there's a sticking point, and like I had one in a case a couple of weeks ago, there was a sticking point, and we just waited until the judge what the sticking point was and explained it. And it was almost like we were doing a trial, but in pre-trial. And the judge told us, look, you put this in front of me, this is exactly what I'm going to do, and I'm not going to change my mind. And it's a way to go back to your client and kind of make the judge the bad guy and say, well, look, we explained both sides, I fought, but the judge said that this is what they were going to do. So to save you money, you might as well just agree to that. I mean, he's going to do it no matter what. So that kind of saves you time, and it allows the judge to be the bad guy if you have a client who's not going to listen to you.
Yeah, and this goes all the way back to what Victoria was talking about, was in the pretrial, there may be a sticking point, or there could be one issue, and it might be, like I said, maybe one party moving, maybe whether or not the child's testimony is going to sway the judge. There's a lot of things that could be a sticking point, and probably it's unique in each one. But once that sticking point is done, then the rest of the case may settle itself. This is why I was advising you to tell your client from the very beginning about that there's 3 different kinds of settlements. And one of them is the judicial settlement, where we're going to go to court and the judge is going to tell us 3 or 4 things, and that's going to affect it, because now we're going to be under the gun to make a settlement. And clients that aren't prepared for that are going to be in a much worse position. And you can almost always see that the other side has not been told that this is a possibility, that the judge may tell you something in the first 10 minutes that may impact your ability to settle it. And now, if we would have only known how a judge is going to rule on that one issue, that now we're at settlement. If you prepare your client for that beforehand, they're not going to be surprised when that happens. And I think that what Victoria was describing probably happens half the time, maybe more, where a judge will say like, hey, no, I'm not going to make the client pay for that, or I'm going to make that client go to have a drug test, or whatever it is that that you've been fighting, or whatever that issue is. Okay, now the trial begins. In this book, I say that I like to call the other party first. That is just a personal preference. It's not something that that I would say is mandatory, but I think what it does is a couple of things. Number one, you may not know what really is at dispute. The other side might actually agree that your client should be the one that has custody, and that they should have whatever it may be. They may have something that they want to say about your client, whatever it is. This allows you to really be able to find out what is in dispute. Now, it might even take them off guard, right when they were settling in, to hear what you had to say. Suddenly they're on the stand. So there's some benefit to that. And it may clarify to you, like, look, this defendant is really testifying well. And your client can hear that and say, like, okay, what is? Now the client's going to be mad, and I'd say you just hand your client a legal pad. I always have 2 legal pads. Give them one to write on. Say, look, I got work to do while the other side is testifying. And if you want to write at the top, put lies. I get it. You believe that everything they say is going to be a lie. I've got to hear it. So I've got to listen to it. You don't need to write that down or tell me she's lying. I get it. Everything I'll just assume is lies. Just write down what the specific ones are. So I'll know. That's a strategy for me. I know, like, for instance, if you're in front of Judge Mann in Mecklenburg, she does not like this at all to call the other side. She thinks that you should put on your case, and she says that allows the opponent to, because now they get to cross-examine their own witness, and allows them to ask leading questions, which she doesn't like. It's up to you as to how you want to go about that. I mean, to me, it's just something that moves the case along a little bit quicker. So if nothing else, when your client's getting up there to testify, they don't have to guess which lie the party is going to say. They know. Now you know that they're going to say that your client never has taken them to a doctor's appointment. Well, maybe your client's gone to every doctor's appointment, and your client's able to really get to the point on that. Or maybe they'll say, like, yeah, she's taken them to every doctor's appointment. Well, now I don't have to worry about that. That fact's established. They've agreed to it, and I don't have to make a big deal about it, if that makes sense. Okay, as the trial begins, just some common objections, because you've learned all these rules of evidence, and it really comes down to about 5 objections that you really need to know. All the civil procedure in 1 page. Number 1, hearsay. You have heard all this time about hearsay exceptions. They are a figment of your judge's imagination. They almost never give you a hearsay exception. They would just say hearsay objection. Or they might say, I want to hear that, which is not a hearsay exception, but that's just the one that they use to find. Like, I want to hear that. Like, but you can't hear that. But okay, I want to hear that. That it means hearsay overruled. So, you can have your hearsay exceptions ready, but just be prepared that in general, the judge just considers out of court statements as in hearsay. If the other party said it, they consider it non-hearsay, even if it doesn't really apply to non-hearsay. So those are sort of the points, like, well, that they said it. I'm like, well, but that's not necessarily non-hearsay. Here's one, just know that in general, they're not going to do that.
Just a quick question. I've had a lot of judges recently allowing what children have been saying to the parents as exceptions to hearsay.
Like state of mind.
Yeah.
Like the child's state of mind is not at question. That's,
Okay.
yeah, I
I
know.
didn't know if it was something. Like I objected to it, judge was like, that's not hearsay, and allowed it. I don't know what to do in that situation, I guess.
Well, this is where, yeah, Nick's saying this, and I've actually taught a CLE about preserving your record on appeal. First of all, I don't want to get you guys too caught up in that, because the reality is you better win your case in front of your trial judge, because it takes even if you're absolutely right, it's going to be a year, 2 years down the road before you can get anything. Is that really the way to handle family law? But if you have an objection that is clearly that's clearly hearsay, I don't see any exception to it. And on top of that, children's testimony, it should be considered the most unreliable in terms of what's being said. Then so like, Your Honor, I don't think any exception applies to that. So I'm noting my exception, my objection. And they say like, well, it's overruled. So like, well, exception noted. That's it. That's probably enough to get that in. I don't think that this is going to be a great time to do a dissertation. And most of those objections that you go back and forth on in terms of the Court of Appeals was a jury trial. Our judges are finders of fact, and they're the ones who make the ruling on the case. So it is exceedingly difficult to get into these things where you're digging in and you're not wanting to create much of one, but you definitely want to say like, Your Honor, objection noted, and then say like, Your Honor, I'm going to object to all of the statements of this child. So, and you can just continue to object, but at some point, the Court of Appeals has said that a continuing objection can exist. But it is very difficult because you're trying not to antagonize that judge. At the same time, you're wanting to make sure you're building your record up on him. I think it's a tough one to do. So hearsay is definitely going to be one. Number two is relevance. The judges don't want to go into a deep background on the parties. They'll start testimony on a new case when the child is born, generally. If it's occurs before that, you better be prepared to make an argument. And if it's a modification, the court's only going to allow things to come in from since the date of the entry of last order, even though unless there was like a consent order or something like that, you've got to be able to show what the circumstances were at that time. They're just not going to give you much ground on it. The objection you'll hear the most in trial is one that is not even an actual objection. You will hear him say this: timeline. And that is not something in law school you'll ever find it in, but you'll hear them say timeline in court a lot. And what they mean by that is an objection of relevance. So when you say timeline, what that means is you have to ask the court, okay, can you tell me when that happened? You can ask the question, they're just saying like well, when did he start abusing you? Okay. And that's multiple objections in that, but one of them is relevance, because if it happened 10 years ago, that may not be relevant to what's going on here. So you just have to say what the time is. And that is okay to say it. What they're doing is they're saying, I object, Your Honor, I object to relevance, but it's specifically, I know it would be relevant if it was within the distance of this time. So it's a little bit of an encoded way that lawyers will say and make an objection on it. Documents, you can testify as to statements on your accounts, pay stubs, and otherwise, even though that's actual hearsay. There's even some case law about medical records. You can bring in medical records if they are sealed and sent to the court. And so there's a format for doing that. You just have to do that before trial. So just ask the medical provider to send records to the court order under a seal. The court can review them. You must do it prior to the court date. Photographs are simple. I have to ask if they're fairly and accurately portray what is shown. I one time won a criminal case because the prosecutor completely forgot how to say those words. It was a theft case, and I couldn't believe it. But it was Judge Fox, and he was He looked like Robert E. Lee. I mean, he had the white beard, piercing blue eyes, and he believed in the rules of civil procedure. And I said objection, and he said sustained, and I about fell out of my chair like, oh my gosh. And the prosecutor was not ready for it to be sustained and just could not remember how to say fairly and accurately portray. And it's like magic words. Just remember those two words. It doesn't matter who took the photos. Doesn't matter if your client has even seen the pictures. All they have to do is be able to say that fairly and accurately portray what it looked like on that day, or whatever it is, and that gets it in. Text and email. This is probably the biggest one that will come up in your cases. This is how you get in a text or email. You can identify the messages from the other party, recognizing the cell phone number, email address, social media site. That is you first authenticate it by saying, okay, I see that this is a picture of your phone. Can you tell me where that is? Okay. Who is that at the top? That says bastard. Is that what you label your ex's name in your phone? Yes. Is it true that bastard has sent you other text from that email message? Yes, they have. Here's where they did. They sent an innocuous one the day before, like, gotta pick up, going by the school to pick up the kids. Is that clearly the defendant? Yes. So we have authenticated it as being that. They can voir dire at that point, your client, just a question like, well, this bastard could be any bastard in your phone. Like, no, it's not. It's capitaled. Whatever it is. You see what I'm saying? I mean, if it's authenticated, then that allows it for it to come in. And it can be authenticated by that. Well, somebody could have gotten a hold of that phone. Your Honor, that goes to the weight. My client's authenticated it. This is what, where it is, and has identified it as being the defendant. And that's not hearsay, so it comes in. Right. So I don't think that would be those objections. I think a lot of our attorneys stress out on getting text messages in. It's really not that difficult. And most judges I've seen are pretty liberal at letting that in and just being like, yeah, this looks like the kind of stuff. They're more like, look, it looks like, most of the time, what I always think is really bad on the other side, the judges just look at text messages and be like, this is just two people arguing. These children cannot get along. I'm going to do 50-50. Even if it's like clearly one side is the one doing all the bad, like, well, but judge, don't you want to like throw a flag at them? No, I'm just saying this is terrible. Terrible that a child has to be in this spot. Okay. All right. So, I believe presentation of evidence should be pretty quick if you can, but it should be fairly thorough. I am not one to write out my questions. A lot of people are they write out questions. Completely okay. Either way, just know that if you're using a list of questions, use common sense. Like, okay, the judge is not buying any of this. I need to stop asking my questions that I pre-prepared. Or vice versa. If it's a situation where it's like, oh my gosh, my client, I didn't write questions out, my client's gone off script, go back, pull out your complaint and just say like, okay, let me make sure. I like to do that at the end of my client's testimony because I don't want to miss anything that's in there. Like, okay, let me make sure, did I ask for child support? Did I get my client to testify as to that? And so things like that. I think that's just a good guideline to go back to. But I'm completely in favor of you writing out questions if it makes you feel better about it. I like to tend to just go down an outline. But in the end, don't miss something because there's something important for you to get out in terms of that. After the trial, I believe we should be the one to try to draft the order, win, lose, or draw, because I put in, you tell the client from the beginning, there is another phase of settlement, and that is after the court. The court will almost never give you a full absolute order. It's always going to have some holes in it that you can throw in some extra things into it. So, try to be the one to draft the order if at all possible. Make that your job, and, the courts will appreciate that. And if you get good at it, it'll be to where you are drafting orders even when you lose, because the judge likes for you to do it, and you can mitigate your losses in that order. I mean, obviously, I don't mean rewrite what the judge said. I mean, if the judge didn't put in Christmas, well, Christmas might need to be a little bit longer, under the definition. But if the judge, there's things that you can do in that drafting of the order that might be beneficial. And of course, the flip side is also true. If the other side is ordered to do the order, you might want to do one anyway. So because that it's there, and then you have several judges in our practice or our practice area that will almost always ask for both sides to prepare a order anyway. And that's really easy because that is tab 6 of our trial notebook. We're ready to go. We knew what we wanted as far as being the order from the beginning. Okay, Patrick, I don't know if you're still there, if you want to talk anything about trials,
Can you hear me?
trial process.
Can you hear me at all?
Anna, Victoria, anything you guys want to have?
Text messages, because the judges really don't like, it really seems like they're not reading them after you hand them to them. A lot of times, like the really dirty ones, but the other side is all the time objecting to getting that done because they're about to be admitted into evidence anyway, and they know that. But I would just then tell a judge that you're just highlighting some things, because I feel like after we introduce them, a lot of times they don't read them, but I mean, so I like to have like 5 I'm trying to hit real quick. Yeah, and I think if the judge orders the other side to draft the order, I mean, we have ours ready, so right after you can send it to the other side and say, hey, this was our template, we had proposed this already. And a lot of times you'll find that they're lazy and they'll use our order anyway. That's a few things that the judge did, which is helpful. Way to sneak it in there.
Just too, if they don't want to tell you exactly, they don't want to say like, oh, this person, quote unquote, won or whatever. You'll be able to find out when they ask for it. A lot of judges will ask certain people to especially if your side did quote unquote win, they'll be like, oh, Miss Corey, will you got that? They answer or the order. So you kind of get it.
We don't want to say it in front of your client.
That's just in trial. There's a lot of times where you're like, what do I do? Let's say the other attorneys. Whatever it is, a lot of times I think our judge is kind of looking at me like, I've been doing this a while. Help me out here. Listen to the judge.
The processes and procedures are a good default for when you're starting out to make sure that you're presenting your full case, and that a lot of it will depend on your district and how you learn your judges and your other attorneys to know whether or not you're really going to use all those. And especially when it comes to evidence, I think I have a case next week that's preempt. And I know the attorney on the other side does not want it to go longer because we only have a day. So I know probably I can get letters from teachers and things like that, and I can send them to him ahead of time and say, hey, I plan to introduce these unless you want me to subpoena so-and-so. I know he's not gonna want me to subpoena so-and-so. And that works out to get that out of the way ahead of time. And you can do that sometimes in pretrial orders too, if you don't really trust the other side, that we agree to this pretrial order consenting and stipulating to these things coming in as evidence, I think, to work some of those things out. But at the beginning, you should just subpoena those until you learn it.
I was about to say, I think it comes with time, like, who you can trust. Your opposing counsel, not necessarily trust, but like when Garland Byers tells me something, I know that's exactly what he's gonna do. Whereas if Mark Morris tells me something, I know that it's completely gonna be the opposite.
Well, you trust but verify, get that,
Yeah.
get that writing that says, yes,
Yeah.
I'm stipulating to these things.
Ever 100% front us. Just make sure that you can trust opposing counsel wise, and especially in all the counties that Anna's been in, or Patrick Bryan or Brian himself, they know who they can trust in their accounts. So that could be good resources.
And I wrote my questions for years before it turned into an outline, so it's fine. Just don't get so nervous that you're reading your questions and the client didn't say what you thought he was saying. So you ask that follow-up question because that's not gonna work out. I've had people cover for me and use my questions. Like if I'm sending somebody, then I make questions, so I don't feel like I'm leaving them stranded, but then they just ask the next question, but it no longer went with the flow. Guilty.
See, oh, Patrick is. Patrick, you back with us? Kayla, can you give me that? Right, yes.
Can you hear me now?
Patrick, do you want to, can you join us? I don't know if it. All right,
Can you hear me?
we can hear you.
Oh, wow. You can hear me
We
now.
can all see you. In fact, you're
Oh, that's not
you're being
good.
protected behind me if you can see.
Well, I apologize. I have seen better days, so I don't know how much I love the idea of being on a big screen.
You look great.
I heard
You wanna-
somebody lie. I heard someone tell a lie. That's if I had the legal pad right now, that would be lie.
Lie. Yeah, there's a lot of lies. All right. Tell us your thoughts on this is on the trial process. It's kind of where we were on this.
Yep. Just some pointers. As you're going through it, you have I know we have some judges, especially over in Buncombe, who are gonna say, okay, everybody give me a proposed order. I've only really seen that in Buncombe, to be honest. Otherwise, I tend to pull out the old phone if I'm in Madison or wherever I am. Pull it out, ask the court, would you mind? They say no, hit record. And that way I have my own little, audio recording of what the judge dictated from the bench. Why? It helps when you're drafting an order, but more than that, because you already know what you want to have in your order. But more than that, it protects you from certain attorneys who like to bake in stuff to their order that was never even mentioned at court. Judge didn't say it, so it's easy. I have even pulled out my recording for the court at times. So I do that. Going into a trial, like Brian said, you're not going to get an opening most of the time. You will get a closing, maybe, if you ask for it. Some judges won't give you a closing. Some will. I always ask for one. because it lets you put a little bow on your presentation and on your theme and your narrative. And that's something that I like to do in every single case that I have, is going into it. I have a theme. I have a narrative that I know I want to get across to the court. What is that theme? Build on that. I start with a closing. I know Brian says, and I think because I missed some of this, but your proposed order is already drafted before you even go into trial. Same deal. I start backwards and go from there. So drafting a closing argument. What is your theme? That really directs everything. And I just find that very, very helpful and a lot more effective as well than your vanilla run-of-the-mill custody attorneys who'll just go in and say, okay, you got a house, you got room for the baby, which that's effective sometimes, but you have a theme. It's always helpful. One thing about pretrial that I want to talk about, because I was trying to pipe in and I couldn't. Pretrial on WebEx. In Buncombe, they still do a lot of WebEx, right? And who knows? We may always do it over there. I had a situation once where I had my client come to my office for trial. It was a WebEx trial, but I wanted my client in my office. Judge wants to pre-trial. I send my client out of the office. Client goes, leaves the room, and unbeknownst to me had gone back and placed her ear on the closed door of my office and was listening to everything, and did the same for like post-trial debrief. So just a little warning, escort your client to the lobby or wherever before doing any of those WebEx pre-trials or post-trial debriefs with the court. Those are just general thoughts.
All right. You have good questions for Patrick? All right, let me take us through, and what we're going to do is try to, if I can pin that back. Yeah, reverse that. All right, I want to go through very briefly the family law checklist to kind of wrap up this morning session. And in the afternoon, we're going to get a little bit more into practice areas, so we can really dig into those. But I think it's really important, first and foremost, for us to have that sort of professionalism. This is what we do every time we go through these trials, the exact same, or family law cases the exact same way. Number one, client retains. CEA signed, you've got all of those things, you're moving forward. Number two, you do that opinion letter task in 7 days. Number three, a homework task for clients. You want to make sure that you give your client homework tasks. They're not going to stress you out if they constantly have a list of things they've got to be doing. Number four, case manager sets that appointment with a client. Number five, draft all pleadings. Put second eyes on the document like we talked about. Make sure somebody else in the practice area group has a chance to look at things. Set your mediation date. Draft written discovery and send. I like to have that done with the complaint. Sometimes that happens really quick. You do not have to wait for 30 days for them to answer. You can get that discovery cranked up. Check and see when depositions are needed. And like I said, I think you should aim for that every time. Set that court date, do a notice of hearing, make sure you send subpoenas, and have a good trial notebook. You do those things, you will be the best prepared attorney in your case. You will know what's going on. You're going to feel good about it, and you're going to be on top of that. In the meantime, a few things that you guys know that we do every other week, you should be doing a case review. Patrick is really working on this. All the attorneys in the family area practice area group we're doing case reviews of family law cases with family law practice area group. And that is going to make you feel like you're sharpening the saw on each one of your clients. You're walking out of each one of those case reviews with a new task for you, and you're doing that with your case manager. So you're doing one, with another attorney, you're doing one with a case manager. You're trying to get as much possible going through that. I put that on the case managers, but that, that process needs to happen. And then, of course, it didn't happen unless your time entry is in CLIA. It doesn't matter what kind of other things are going on. You're constantly putting your time, your stuff into CLIO. You can see this is sort of John's breakdown on how to do that, and sort of a breakdown of that. I'm preaching to the choir. This group does a really good job. We just, for the new people that might be listening to this in video, and hopefully this is going to be part of our training program, then it'll be it. So let me end our recording where we coming back in specifics. And I will